Hey y'all, I'm Mayer Cunningham, the special education boss. If you've ever felt confused, overwhelmed, or just plain frustrated at the 504 IEP table, you are in the right place. Every week, I'm breaking down the rules, the rights, and the realities of special education so you can walk into meetings informed, empowered, and ready to make real change. And whether you're a parent, a teacher, an advocate, a school-based member, or somebody who's just trying to do right by a student, this podcast gives you straight talk, real answers, and tools that you can use immediately. I'm not here to play politics. I'm not here to play sides. I'm here to train people who sit at the table and teach you how to follow the law, ask the right questions, and protect the rights of students. So go ahead and hit subscribe, share this with a friend, and you know what? Meet me back here every single week. We're not just talking about change. We're making it. Because when you know better, you do better. And when we get it right for the child, we get it right for everybody. I just wanted to pop on and give you guys a little training about due process hearings. If we haven't met, I'm Mayer Cunningham, special education boss, training everyone that sits at the 504 IEP table to navigate and negotiate successful student outcomes. If you don't follow us, please download our app at Special Education App. That's not true. That'd be great if we owned that. Special Education Academy. Our podcast is Special Education Boss. And of course, you can always reach us at advocate@specialeducationacademy.com. We certainly want to give you guys as much information as we can without, not protecting the rights of our families. So I heard that you guys like to look and learn. So we're going to do some looking and learning. And so a due process hearing is a parent's right to look at resolving an issue as it relates to special education by an impartial due process hearing officer. It's not voluntary. Some of the dispute resolution options are contingent on the other party participating, but due process hearing is not voluntary. So I kind of want to walk you through the steps of how we get here, how hopefully we don't get here. So when I train you guys, I tell you it's about data, and it's about paperwork. You need to make sure that your paperwork is going to pass the hearing test, right? And the due process hearing test. And so when we get paperwork from families, we'll have families that say, oh, Karen, we've been complaining and disagreeing with the district for years, and nowhere in the paperwork does it exist. And so I want you to know that if you ever go to a hearing, everything that you have said and typed and emailed will be used, and it may be used against you, even if you said the nicest things, right? So, so we filed a due process hearing. I've had 3 this fall already. I had one in August, one in September, one in October. We're about to file 2 more. I don't want to file. What I want is resolution. So remember, the best, most successful way to get to resolution is by resolving your issues at the IEP table, right? And so that's one of the reasons we wrote the EPIC IEP. It is my life's work. It's a powerful playbook for parents, educators, and advocates navigating the special education process. And we're all navigating it, right? It moves all the time. So I wanted to give you a little bit of a visual. So when you go to a hearing, there's some steps in between. Obviously, you need to get somebody that can represent you in a hearing, somebody that knows those requirements and the expectations of when you're doing examination or cross-examination, the rules of that. Sometimes it could be a special education advocate, but almost always people will get a law firm. You want to make sure that if you have a law firm representing you in a due process hearing in special education, that's their specialty, right? A lot of people will go, oh, my uncle, he does litigation for, car wrecks, which is great. And maybe this does seem a little bit like a car wreck, but special education due process, you need somebody that does that they're a special education attorney. And there are very few out there. So make sure that when you get one, they know what they're doing. So we filed the due process hearing. There's some steps in between. The first step is almost every state has a statute that if you file a due process, the requirement is within 15 days, 15 paper days, that you go to a dispute resolution session that is hosted by the school district. And so be cognizant of that. If you file on December 15th, then you would have to go to that resolution by December 30th. So make sure that you know that. Timelines in due process, timelines in a state complaint, timelines in a mediation, timelines in a federal complaint with the U.S. Department of Education Office of Civil Rights are not impacted by the instructional year. So they go on continuously. So you go to a dispute resolution session. If you don't resolve that matter, then, I would tell you to go ahead and participate in mediation. You always want to be amenable to resolving it, right? That's our want and our wish, is that we can resolve it, not that we can just keep spending money on all of these legal processes. And so then the parents and the parties go to mediation. If that's not resolved, then you go ahead and go to the hearing. And so it's not cable TV, it's not HBO, it's not a Cinemax movie. It's an administrative hearing, and the judge allows in exhibits that are, one, relevant to the facts of the case. And so the facts of the case are the same facts of the case when we're at the IEP table. And so a lot of things when you're in the IEP process and you're a parent feel wrong, but they're not necessarily illegal, right? Two things are illegal: procedural violations and substantive violations. So procedural violations are sort of the processes that have happened along the way. Certainly there can be a procedural violation that then does rise to the level of being a substantive violation. A substantive violation is really the meat and potatoes of what has happened, the denial of FAPE, the students being harmed, and then how that occurred through that denial of FAPE. So go to, if you guys want the book, and you do, go to Amazon, get the Epic IEP, come back to the epic-iep.com, put in your information, and we'll release $500 worth of pre-order bonuses to you. It's going to change your life. Get one for you, get one for somebody else that needs support in the IEP process, because we all do. So we're getting ready for our hearing, and we prepare exhibit books, right? And so if you've ever seen a case in court, there are exhibits, there are documents, there are videos, pictures, all sorts of things that the attorneys are directing the jury and the judge to, right? There's no jury in a due process hearing. Sometimes I wish there was. There is one assigned due process hearing officer. And due process hearing officers are as different as any other kind of people, but they are charged with looking at the facts of the case. And the facts of the case are solely exhibits in the case. That's it. That's not like how I feel or what Elena did to me or Travis didn't let me have a good parking space. All of that is not an exhibit. So let's kind of talk about what these exhibits look like and what both parties will put on their case in chief to prove up their position that a denial of FAPE did in fact occur or a denial of FAPE did not occur, right? That's going to be the district. So I put mine in different color binders because if you know me, I'm very color full. I'm very colorful and I'm very colorful. So I always put my joint exhibits in white binders because I feel like that's the neutral lane. So what are joint exhibits? So these are the joint exhibits for this student. They are lengthy. So joint exhibits are going to be exhibits that both parties agree to. Neither party objects to them. And so what are those exhibits going to be? So, and it goes back to the history of the student's IEP, even if it goes outside of the filing timeline, right? So for a due process hearing, in almost every state, you can go back and you can talk about areas of violation of FAPE for 2 years, right? So, so whatever the date is of the filing, so let's say that you filed December 10th, 2025, then you could talk about allegations of a denial of FAPE and other components of IDEA back to December of 2023. So make sure that you have, when you are IEPing, whether you're the parent, teacher, educator, that all of the documents exist somewhere, right? All of the documents exist. So in this first page, it will talk about joint disclosures. That means both parties agree to these disclosures. So it is going to be the student versus the school district. And these are documents of evidence. So on these exhibits, number one is a referral documentation. So that is going to be the initial notice and consent. It's why I tell you to sign the IEP. I don't care what somebody else told you. They're wrong about that. They are wrong. Sign the IEP. Because when this goes before a hearing officer, they don't know how you felt that day. They don't know what happened in the meeting. They just know you didn't sign. So participants, sign and capture your position. So the referral documentation, the initial evaluation, the initial meeting, the notice for health services, a review IEP, the attendance records. And see, these are all things that happen in the natural order of the district keeping records. And so these are all of the evaluations, the IEP meetings, the review meetings, the special services the student's receiving, health services, another meeting, an attendance log, IEP progress reports, a health record, any of their supplements, those, transition, behavior intervention plan, ESY, letters if they relate to the student not passing certain tests, state testing, district testing, and then the calendar for the school district based upon the 2 years that you filed. So joint exhibits are always going to be all of those legal documents that sit inside of the student's IEP record. It is important, whether you're advocating for yourself or your child, that you always prepare your file like you're an advocate, because you are, and make sure that you always have all of those documents always, and that you always understand what they mean, that you've outlined your questions, and that you've captured your position in the deliberations the way you want them captured. So often when we're in a disagree IEP meeting, the district, when they write the deliberations, it favors them, right? And so ask for that to be corrected when they're reading the deliberations. If they won't correct it, then I send a follow-up email and say, hey, ABC Independent School District, this is on behalf of the parent. This is our position of what occurred today at the IEP meeting. Get that in the record, because if it's not in the record, it didn't what? It didn't happen. If it's not written down, it never happened. And I hope that you never disagree. I hope you never disagree at an IEP meeting. I hope that you have no idea what I'm talking about. But disagreeing is part of the human experience. I don't know why we're so shocked about that, right? And a parent disagreeing with the school is not unusual. The school disagreeing with the parent is not unusual. But I promise you, the school will have their position captured. So make sure that your position is captured. Hopefully just so that we need it of record when we go to IEP meetings and we can have conversation about it. Hopefully you'll never have to go to a due process hearing. But I promise you, everything that occurred in those meetings, the district is going to have their documentation. So these are joint exhibits. So there were 15 joint exhibits, and those are exhibits based upon the student's need for special education and related services that both parties agreed to and neither party objected to, okay? So the next book is going to be Petitioner's exhibits. So I always put Petitioner's exhibits in blue because blue is for authority, and I believe that we are looking for an authority to give us the right recommendations going forward for this student. So in this book, I have all the petitioner's exhibits printed out. And then additionally, there's digital exhibits. So let's talk about digital exhibits because what's the saying? A picture's worth 1,000 words. A video is, it's everything, right? So when I have clients, I'm having them do lots of digital products for me just when I'm even representing them at an IEP meeting, right? So, and we teach you that in the Epic IEP. Go get the book. The Epic IEP is on Amazon. Just get over there, order it, and then come right back to the epicip.com and put your information, and we'll release $500 worth of pre-order bonuses. So the petitioner's exhibits, which are the same sorts of things that I have in my folders when I'm representing a family. So it could be, you guys know that I love a good 3-minute cold read, a 3-minute cold write. I have parents video that. I have information from the outside reading tutor. I have information from maybe the lady at the daycare that every summer he goes to daycare, but he doesn't need any behavioral support there. I'm going to capture how the student's disability impacts them across settings. And so I'm going to be collecting that anyway, especially important if you need it for a hearing. So what do the petitioner's exhibits include? 1 through 12 were just paper exhibits, right? And then digital exhibits could be this. They could be a video. They could be an audio. They could be a video audio. That would be digital, right? And so those don't necessarily are going to exist in the school records. Remember, like I tell everybody, assume if you're on this planet, you're being recorded. Just assume it, right? One of the exhibits we got into a hearing in August was a video recording of when this single dad had to go pick up his son, what the teacher, not the teacher, what the principal said. The principal was, what's the word I'm looking for? Ugh. She was very ugh, right? And people in the moment when their amygdala is firing will just kind of, there's no filter and they'll say it. And you are bound by what you say, right? You are. And so often when districts are telling a parent or threatening a parent with a different placement, they tell them that. They don't type it out. They don't say it at a meeting. But that was an important piece as we went forward legally, because it was the district's position. So when you are on the planet, you can assume that you're being recorded. Obviously, there are 6 or 7 states that you can't record. But other than that, these recordings they have to be authenticated. What does that mean? That means when you go to a hearing and there's a recording, obviously the school district's going to object to it because it's not authenticated. So the person that did the recording would need to be a witness. Then your representation or your counsel would say, as we sit here today, do you affirm and indicate that this is a clear and accurate recording of what occurred? And of course, the person's going to say yes. And then that attorney will ask the hearing officer to accept that into the record as an exhibit. They are important. They are important. I don't find that when people act terrible to parents that they type that out in a document. I don't find that out, but it might happen where you live, okay? So exhibits, let's kind of talk about what the exhibits are for petitioners, right? So our exhibits had to include the student goes to a private counselor because he has emotional needs. We have documentation of the camps that he went to in the summer. A lot of the school district is saying that he's not successful. He can't do work. He doesn't finish his work. And then we have recordings, videos, and documents of him doing work in other settings. We have his tutor's letter. We have a letter from the physicians that he sees. He had a surgeon. We had that information. And then we have a lot of emails back and forth between the parent and the district. And so we have those. We have so many things. We have pictures, lots and lots of pictures. Pictures worth 1,000 words. We have conversations that were recorded. We have audio of when the parent went to the school just to get open records, and he recorded that on audio. And the clerk said, we're not going to give you open records because you're already in a hearing. Oh, problematic. We have the student using their accommodations at home successfully. We have the student doing home health and homework. We have a video of the student when he was at the summer location where he got a reading program. So we have all of that. And then also we have our witnesses, right? So who are the witnesses that you are going to call? Who are the witnesses that can firm up your case? You can be sure the district is going to call witnesses. So who are those people that know your child, know about their unique circumstances? And those would be pieces of the petitioner's exhibits, okay? And again, depending on the hearing, I would have a lot more books for petitioners, except for over half of them were digital exhibits. So obviously I can't print out an hour and a half meeting. And you will find out that even when the school district records, when you go to hearing, guess what happens to those recordings? Like my natural hair color, they evaporate. So it's very important that after your meeting, if there's a recording, even if I'm recording, I say, dear ABC School District, please provide the parent a copy of the school's recording. Because I don't think it disappears, but sometimes it disappears. And so if you are talking about something that happened in a meeting, but you don't have a recording, the hearing officer is not going to really take that in as much as they would consider an actual document. So then we have the respondent's exhibits. I put them in red because I want them to stop. That's why I put them in red. So we have the respondent's exhibits, and for this case in August, they were this big for the actual ones that I could print out. Of course, they had some digital products as well. So the respondent, who is the respondent in the case? So the respondent is the party that didn't file, right? So that's going to almost always be the school district. The parent could be the respondent. In certain very few cases, if you would ask the district, you know, in Florida for an IEE for your child's AAC evaluation that was 3 sentences long. And so when my parents asked for an IEE and the school district in Florida took her to hearing. Oh, good job. Okay. But in most cases, the district's the respondent. And so what is the respondent going to include? They're going to include things that were not in the joint exhibits, right? That IEP, his IEP progress report, things that weren't in, that we agreed upon that weren't at IEP meetings. So they're going to have different things that might be in the student's cumulative folder, but wouldn't necessarily exist in the IEP document. So they might have emails, they might have records of training, they might have, this school had records of, he was in a self-contained class, so there was a log. It's a behavioral class that uses the Boys Town system, because that's a good idea. We should have disabled kids earn points every day so they can be with their non-disabled peers. That's a good idea. You know, the greatest graduate from the Boys Town curriculum was Charles Manson. So there's that. So they had records of the Boys Town, what am I thinking? The curriculum that they use, the protocols, which is interesting because for the 2 years that we asked for it for the little kid, they didn't have a copy of it. But guess what? They got copies of stuff when we get to hearing. They had emails between the student's father and then his private counselor. They had his 504 records. They had, which is true, before an advocate becomes involved, they had, you know, that the parent had denied special education. And that's, so often the schools have the outcome, but it doesn't capture what happened. So the dad didn't know that a special ed was any different than a 504. And in the meeting, he was talked out of it, right? But that's not in the documentation. In the meeting, we don't say, hey, we told Mr. Smith, you don't want that. He has a medical condition. You don't want that on his record. None of that's in the paperwork, right? So it's super important that when you're the parent or the advocate, when you go home, that you capture what occurred and send it to the district. It then becomes part of his record, especially if it's not the way what they've captured is not what you experienced, right? So then we have emails back and forth. We have, for this kiddo, he had a lot of absences because we had lots of med changes because of his trauma history. We had, they captured all of that because they're saying that we couldn't provide him a free appropriate public education because he was gone so much. He leaves twice a week for private counseling based on the trauma. And of course, they captured all of that. They captured when he had a little hearing, he had to have a hearing because he had done something wrong. And they have that. It's very rare that they would have the parent's position or when the parent and the advocate became involved. So it's very, as an advocate, if you're representing a family, you make sure that you send your position, okay? We have when attorneys became involved from the district, the advocate had reached out to the superintendent. It was an assistant superintendent, not that it matters. We had gone to mediation with the district prior to filing for a hearing. There are emails that the advocate needed to reschedule because she didn't have an opening in her schedule. Okay. Know that if you go to hearing and you have an advocate, 2 things are the problem: the parent and the advocate. Just FYI, just want you to know that. So for this, it was the advocate and the dad. Okay. Photos, records, and then of course for the district, they have resumes of the school district personnel. They might have affidavits, and then they also might have other things. So the district has the right, or both parties have the right to subpoena records, and so that does occur. So I just wanted to kind of give you an overview. We live and die by data. We live and die by data. We should be doing it, period, in IEPs. 2 things happen at a school: instruction and production. We want to capture what's happening for kiddos. We want to capture what's working, what's not working. But if you're going to prevail at a hearing, that's my lunatic dog. If you're going to prevail at a hearing, you have to have paperwork that a stranger, the hearing officer, can read. And it's got to be clean. You know, often we have in emails, most parents are really, really super nice. And even when they're going through something hard with their kiddo in IEP, they're thanking the school, they're thanking the school, they're thanking the school. You have to be able to soberly write down what occurred and how it impacted you and your disabled child. So these meetings are not, they're not, you know, Thanksgiving, they're not buddy meetings, they're a business meeting. And it's not about being harsh, it's the business of educating a child with a disability. And that is labor intensive and data intensive. And just like we're charged with legally making decisions at IEP based upon data, it is the only thing that the hearing officer is going to make her decision on. And so when you're in a hearing, there's a lot of moments or whatever, but they're charged with looking at the facts of the case. And the facts of the case were driven by two things: testimony and documentation, evidence, right? And that testimony still goes back to what we call facts and evidence. And so I'm not an attorney. I'm not going to ever be an attorney. I'm not going to ever be a college graduate. But I know this space, and I know how to get kids successful IEPs, epic IEPs. Go get the book. But you will have situations where you're going to go to hearing, and everything that's in the document, everything that ever was emailed from you, text from you, whatever you said ugly, whatever you said not ugly, is going to be used as an exhibit. That's how it works. So I want you guys to know that. I want you guys to have the documentation that you need to prevail. I want the documentation to speak for itself. The document should speak for itself. There shouldn't be exceptions, exemptions. There couldn't be, well, you know, Cindy saw it this way and Terry saw it this way. Because you have that in meetings, even when it's like written in black and white. I was at a meeting one time, I won't tell you where, in a school district in North Texas. And the student has autism, and the head of this very huge clinic for autism in Dallas was there, the doctor, the founder. And she said, you know, this little girl has autism. And the LSP of the district said, well, that's certainly your purview, but we don't agree. What? And so you're often looking at documentation in front of you, and the school will read it and say, we don't agree with it. So, you know, hopefully you never need this information, but if you do, I want you to be ready. This is, you know, I got this yesterday. This is for a new client that we're filing. And she's not a new client. I've had her for years, but those are the documents that I needed from her. What's in there that we're filing? And she's not a new client. I've had her for years, but those are the documents that I needed from her. What's in there? Every day she took a picture of the behavior log that comes home. Every day, take a picture of what goes home. Because guess what? We've been asking for those logs since, I don't know, several weeks, and guess what? They're not there anymore. So you have the data to reinforce your position, not to go to hearing. Nobody wants to go to hearing, but we make decisions based on data. Otherwise, we are doing it outside of the expectation of IDEA. So IDEA, the Individuals with Disabilities Education Act, right? The federal law, which I'm sure you guys all have this book. Do you guys all have this book? Do you guys see this book at school? Anybody ever see this book at school? No. So this is the Office of Federal Register, right? And so we make decisions based on the federal law. It would be important that we actually know the federal law. I'm sure your school has a copy of it. You can go to Special Education Academy. This is in our bookshelf. And so IDEA was built, written on the consensus model. What does that mean? It doesn't mean that we come to consensus, but it means that I can describe your position, even if I don't agree with it, and vice versa. And so documentation trumps any conversation, even if it's a conversation about agreement. Everything needs to be documented. If you don't have it written down, it didn't occur. It didn't occur. It didn't occur. And so hopefully you're able to present your data in an IEP meeting. You never have to go to hearing. You never have to do any of that because it's tough. It's tough watching your client cry. It's tough watching the school district basically say that your client's child doesn't have any skills. But the school district attorney is there to protect the school district. And lots of people seeing this will be school district attorneys, but it's true. The school district attorney's client is the school district. The school district attorney, their client is the school district. It's not you. It's not the parent. It's not the student. It's not. And so often we get in meetings with a school district attorney and people act like they're, I don't know, Judge Judy. They're not. They're not. They're the attorney for the school district. Yeah, so the book is The Federal Law. So this is the Office of Federal Registry. Sorry, it's super dirty because I actually use it. The Code of Federal Regulations, Title 34, Volume 2 of 4. So IDEA, the Individuals with Disabilities Education Act, is broken into 4 parts, A, B, C, and D. So we are accountable for Part D. And IDEA is a federal grant system that releases grant monies to states because they write a letter every year saying we are going to meet our duty obligations under IDEA for students with disabilities in our state. So I hope that's helpful. Was that helpful? And, you know, special education due process hearings are very rare. In Texas, we have 5.5 million students in Texas. 800,000 of them have an IEP. Annually, about 600 to 700 due process hearings are filed. 95% of them settle. That's good. That's good news. But about 25 to 30 actually go to hearing. And so while you can always get a copy of the decision, it's good to know what happens when you're actually preparing for a hearing. And then I have a client that we're about to appeal a decision. And then after that appeal happens, we'll be doing a webinar with the grandparents for this kiddo because my families are very generous. And we want you guys to know what actually happens. In a hearing, there's a winner. What it took to get here is not a win. Nobody's like, oh, this is so much fun. But schools are obligated to deliver a free, appropriate public education. Do I believe that the procedural rights afforded to parents under IDA bring equity? I don't know that I would use that phrase. You know, we go to the Capitol. We were supposed to go a couple weeks ago, but the government's closed right now. And we are petitioning our leaders, one, to reauthorize IDEA. It hasn't been reauthorized since 2004. And to add a mechanism when the denial or provision of special education doesn't occur for schools and states and districts. There's no mechanism currently, and we're also working with the Texas legislature to get that in place. So, and there's one focus. I always have an agenda. I am running an agenda for special education kids to win. That's my agenda. Very clear about that. And so when we get it right for the student, we get it right for everybody. We can do that. We can do that in 2025. We could do it during COVID. We could do it. And so I want you guys to be equipped as you go into meetings, as you go into any of this process. Know that when you get to a hearing, you know, often when you disagree in an IEP meeting, it's not the school-based members, is it? No, who is it? It's some yahoo from the district, some yahoo that doesn't work at a campus, some yahoo that doesn't work with students, doesn't deliver education. They work at the district, right? And those are probably the people that are telling you that you can't have something in an IEP meeting. But when the rubber meets the road and you actually have to go to mediation or a state complaint or a federal complaint or due process hearing, the people that are called as witnesses are the teachers, right? The witnesses that we had to call in this case were behavioral teachers and RBT, the nurse, because he has self-injurious, the diagnostician, the LSSP, the person that delivered counseling as a related service. You know who wasn't on the stand? All the people that came from the district Yahoo level to run the meeting. They're not witnesses. You know who else isn't a witness? The school district attorney. It was a total jerk in the meetings. She wasn't a witness. So remember that decisions are made, and you don't always correctly win or always correctly not prevail, but the facts of the case have to be in your possession, okay? district yahoos. They are yahoos. Ooh, and not in the best way. So when I'm in a meeting and somebody from the district level is interjecting themselves, I will say, do you teach Billy? Are you Billy's dyslexia teacher? And I appreciate your input, but if we could get the information from the people delivering the educational product, that would be purposeful to populate the IEP. So somebody said, do you take any cases with Dickinson ISD? I live 5 feet from Dickinson ISD. I live in CCISD. And yeah. What types of attorney do you look to hire when you have a 504 student who has behavioral problems? So a 504, you could have a mediation. You could work it out. Probably, if a student's on a 504 and they have behavior problems, you know what they need? An IEP. They need an IEP. So I would get full testing for that. And certainly if you have a 504, you've already triggered child fine. Child fine says that we have an obligation to identify, locate, and evaluate children with suspected disabilities who may be in need of special education related services. If you have a 504, there's no suspected disability. We've already passed that. So all of you in America that have a 504, I need you to email the school district and say we're ready for our full evaluation. And so make sure that you get that done. So we love you guys. We want to equip you guys as much as we can and sort of take you behind the curtain. That doesn't sound good, you know, but kind of see what we do and how we serve families and how we train people to serve families. So if you are a school-based member and you are ready for your school career to wrap up, however that's going to occur, come on, we want to train you. There's 8 million children in America with an IEP. I'm just one person. We have an amazing team, but we want to train you guys to be special education advocates however you sit at the table. Happy Sunshine said, please slow down. Happy, I don't know how to slow down. I have one speed, it's fast. But when you listen to this recording, you can listen to it at a slower speed. That's a good name though, Happy Sunshine. So you get trained by us. We train every Monday night on the Epic IEP Special Education Academy. I train in series. We do federal law, the application of the law, the spirit of law, and really actionable steps. And we teach everything that we teach in the Epic IEP book, which you're going to go get. We have 2-day intensives for people that want to do their best and be their best at the IEP table. And then you get that recording. You can take it at whatever speed you want. And then we have the mastermind people that are wanting to become premier, excellent special education advocates using our proprietary processes. And then we have VIP coaching that's weekly for people that are full-time advocates that have completed the 2-day and the mastermind. Can I record audio on IEP meeting? If it's allowable in your state, almost every state is a one-party disclosure, so you can do that. So you go online to specialeducationacademy.com and, oh, thanks you guys. Thanks you guys. We love you. I want to be of service to the person I once was. You're most powerfully positioned to serve the person you once were. So we are serving those of us that have walked through this process. So we love you. We'll see you guys in the next training. Hit subscribe, share this with a friend, and you know what? Meet me back here every single week. We're not just talking about change, we're making it. Because when you know better, you do better. And when we get it right for the child, we get it right for everybody.